essential part of securing your family future. In today's class, I discuss estate planning. More importantly, I discuss last will and testament. If times allow it, I will tell you the differences between will and a trust. I am Professor Rousseau. You are on Apostrophe Podcast and you are following class and session. But first, let me explain to you why having a will is so important. A will or a testament is a legal document. In this document, you will outline your assets, your properties, or your possessions. Every single thing you have should be on your will or testament. When you list them, you will tell your family, you will tell the court, you will tell everyone who you want to receive your properties. You will tell them how you want your asset to be distributed to the people you choose as your beneficiary. It is important because if you die without one, because your will be executed once you pass. If you pass without one, the state or the law or the court will intervene to distribute your properties for you. There will be some tax involved. They will tell your family the assets that you have and how they will be distributed. This is called probate. Down the video, I will tell you what probate is and how you can avoid for your properties or for your family to go to the process of having a judge to decide who should be receiving what. Now, let's talk about the components of a will. What kind of asset go on your will? Everything. Everything that you have will be outlined in your will. Whether is a property, whether is investment, and don't laugh, whether is a piece of clothing, whether you have a computer, those are your personal belongings. All of those assets will be included in your will, and you will tell the court, you will designate people who will be receiving your assets. They will be your beneficiaries. If there are children under 18, if you have assets that will be leaving for your children after you pass, you have to arrange for guardianship for your kids under 18, somebody that you will choose to control, or better yet, to take care of those kids until they turn 18 or 21. As a recap, your will or testament will outline everything that you have, your car, your bank account, your investment, your property, your toothbrush. They will be listed. That's the first step. And then you will identify who in your family or your friends or in the government will receive your assets, or what asset they will receive after your passing. There are several common misconceptions people have about creating a will. One of the main misconception is that only rich people should have a will. This is a lie. The second misconception is, I don't have any house. Why do I need a will? You need a will whether you are poor or rich, whether you have one laptop, one cell phone, or whether you have 10,000 houses around the world. Another misconception is that a will is a one-time thing. A will is a living document, meaning that you can update your will anytime. If you were single when you have your first will and then you become married, you got married, yes, you have to change your will. If you have one child when you did your first will, now you have a second one, yes, you should have a will. The other misconception about will is that you have to be old or close to dying to have a will. Once again, this is a lie. You can have your will anytime, and you must review your will at least every 2 years or anytime your condition change, whichever comes first. So those misconceptions, do not worry about them. You don't have to be rich to have a will. And once you do your will, make sure that you keep going back to it to make sure that all your assets are listed. For example, if you had one vehicle when you had your will and then you get a second one or a different vehicle, go back and update it. If you were married and now you're no longer married, you are divorced, go back and change your will because the law or probate or whoever will be within your will use whatever is on paper, the one you had first, if you don't make any change. So it's important for you to have a will, and you don't have to be old, close to dying. You don't have to be rich to have a will, and a will is a living document. There is that question that I am asked all the time. Professor Rousseau, how do I begin the process of creating a will? Before you even go see someone, a estate planning attorney or an expert like me to advise you on the right way to do so, start by taking inventory. Dress an inventory of everything you have. And then identify your beneficiaries. After you do that, now in your mind, you will have to know exactly which beneficiary will be getting what after you pass away. After you have your inventory, after you have your beneficiaries, and you know exactly how you wish for your assets to be distributed, consult an estate planning attorney who can guide you through the legal aspect and will ensure that your will is valid. You can also contact me, and if you want to do one right now, tap yes on the comment and I will contact you within 48 hours. One thing important that you need to consider when you are dressing your last wishes on how your goods to be distributed or who you want to receive your assets after you die, you also not required but is really advisable that you establish under which conditions somebody will inherit your properties. Some people will list that if that person don't reach 40 before I die, is not going to get anything. Or they will say if that person is the reason of my death, is not going to receive anything. Once again, talk to an expert. They will tell you how to outline the conditions under which your beneficiaries will inherit your properties. Another important consideration, debts. People have debts. Sometimes they die before they pay them off, which means they are also part of the will. In the will, the individual can specify how the debt should be settled and from which asset. Let's use an example. Let's suppose that your father leaves you an estate, a house that is worth $100,000. However, he has a debt that can be maybe, let's say, $30,000 on the house. Either he had a home loan equity, or maybe he has a HELOC, home equity loan of line of credit. He, he will specify, he may specify that I owe 30K on the house. The house is worth 100,000. For you to inherit that house, you have to be able to pay the 30,000. Or if you cannot pay the 30K, you should sell the house to settle the debt, and you will keep whatever is left, the $70,000. This is important. The debts are also part of the will, which means when you inherit an asset, if there are debt, you also incur the debts, and you will have to do whatever is possible for you to pay. When your father specifies that in his will, it leads to a transparent process for the executor, and it will help avoid some confusion down the road. Now, let me tell you what the executor can do and what role does he play in the estate. Executor, as the name implies it, is somebody who will execute. Is a key figure. Remember that. Is a key figure in the will. This is a person who is responsible for carrying out the instructions that you leave in your will. Your executor is a manager in a way. He will manage everything you say, he will manage your estate. Guys, when I say estate, doesn't mean is a rich thing. Your cell phone is your estate. Your shoes is your estate. So your manager, your executor will manage your estate. He will also pay any debt that you have, any outstanding debt. And also, whatever is left, he will distribute your assets to the beneficiaries you state on your will. Because the executor is a key figure on your will, you have to choose somebody, like I always said, somebody who is capable, somebody who is trustworthy for him to do all that for you. He has to be a good friend. It's really essential for you to have a good executor. If you say, when also in your will, you can select a beneficiary, right? You can also list, if that beneficiary died before you die, you can have a contingent beneficiary. It could be his son, his daughter, her son. You can go down the line to all the way to fifth generation if necessary to pick somebody. You can first pick a beneficiary. You can also pick a contingent beneficiary. For you to know more on how to do that, contact somebody, contact an expert, an attorney, a lawyer. They will tell you exactly the best way to do it and how to list your properties and how to identify the way you wish your assets to be distributed, to whom and what. Now, let's talk about something we spoke earlier, probate. Probate is important, is a legal process that will validate the will. Meaning, even if you die with a will, there are some possibilities that one person can contest it, take it to probate, and the legal process will validate your will. But also probate is involve a court overseeing the distribution of your asset. we assume that you leave a will. The court will share your assets based on the instructions that you leave in your will. I will keep saying it. Always have a will and make sure it's clear. Don't try to use big words. Use simple words for anyone to understand. The probate will ensure that the will is valid. It will ensure the will authenticity. But sometimes when you have to go to probate, there are some is time consuming and also it may incur some fees. There will be some fees associated with it. Some individuals they choose not to go to probate court because they know probate will cost so much and some time consuming. By the time they done, there will be nothing left. If how you can avoid for the court to decide for you, have a good will, have a good executor. You can have one or two executors in case one cannot, the other one will be able to do it for you. As I'm talking to you about last will and testament, I want you to know that is a key critical aspect in planning your retirement like a pro. Better yet, to plan your death like a pro because when you leave this earth, when you die, you don't want your kids to keep fighting over one piece of property. You will tell them which one will be receiving what. And if you don't leave anything, if you don't leave a will or a testament, trust me, the court will be involved. It will deplete your entire estate, and sure you don't want your kids to kind of like not like you because you failed to do one simple thing. Create your will in your testament and make sure that you pick a good executor so the court don't decide what needs to happen to your properties. Now we're gonna try to establish for you. We have some time the difference between a will and a trust. Let me also tell you the will or testament that only is about your properties. It's about also your last wishes when you become incapacitated, or you become when you cannot work, or let's say an example, you are sick, you are in an accident, you cannot have any function of yourself, or you are old, you cannot remember anything, but people want to keep you alive, but you can select someone in your family to pull the plug, to tell the doctor, my father or my mom is suffering enough, you can pull the plug. Once again, it's not only about your properties, it's also about your life when you can no longer do anything for yourself. Now, let's try to establish a quick difference for you between a will and a trust. What is the key difference between a trust and a will? I already tell you what a will is. A will is a simple legal document that provides instructions on how to distribute your properties to your beneficiaries after your death. Simple legal document. It outlines your wealth, your estate. You tell people what needs to be done, how for them to distribute your assets to the people that you so choose. What about a trust? A trust is different, and I advise people to do that when you have so many properties, mostly when it's time for you to apply for Medicaid, if you will apply for Medicaid. So what is it? Is a also a document, is a little complex legal arrangement, is really complex, is complex legal arrangement where you transfer ownership, let me write it for you. Transfer ownership of some of your properties to somebody else, to a third party, for them to manage or for them to have it for you. You can transfer your property to a charity, to an organization, or also to a family member. And when you do that, it helps you to avoid taxes. Next week, I will go a little longer regarding trust. Remember, the trust, when you have a car or a house, you transfer ownership of that house, of that car to somebody else. So they control, they own it, and later they can distribute that asset to your beneficiaries at any time that you determine. If you don't want to do will, you can do a trust. You said, okay, I have this house in Malibu. This house is worth 1 million. I'm gonna transfer that ownership to a friend of mine. The friend is, let's say, his name is Rashid. Rashid can manage the property for you, generate some profits with the house, and you said after 25 years, whether I'm still alive or not, I want that property to go to my son. His name is RJ. Or you can say after I die, whether is a day after I transfer that ownership, that house will go to my son. That's what a that's what a trust do for you. It protects your asset. You no longer own it. Somebody else is managing property for you. You transfer ownership. In resume, so we talked today. We spoke about a mostly living will and testament. What is it important is because you have to have one. If you don't have one, the court probate will decide for you. As I wrap up, the tips I will give you as listeners who will be embarking in the journey of creating your last will, I will again tell you to review. After you do your will, review your will. Update your will to reflect change in your life. You have a new child, review your will. You are married, review your will. You are divorced, review your will. And of course, remember to consult with a legal professional to ensure your will aligns with the law of your jurisdiction, meaning that the law could be different from Texas or Massachusetts. There are some laws, that's why it's a legal document. And also, if you don't have time right now or you don't know who to contact me. I am Professor Rousseau. I will be able to orient you, to give you some advice, and to link you up with the right people who will give you the right advice that will align with your wishes and with the law of your jurisdiction. Thank you for watching Professor Rousseau class in session on Apostle Podcast.